All right, and welcome to How Wealth Rules, Part 6. We're going to be covering a chapter titled The Municipal Colonies of America tonight. As a reminder from last month, we covered the chapter titled The Emancipation of Property from Democracy. And it was a little bit of arcane kind of legal history going back to 1819. The Dartmouth case before the Supreme Court was a controversy between the trustees of Dartmouth College and the state of New Hampshire that had changed its charter, its corporate charter, that was issued by the king before the American Revolution. And I won't get into a lot of detail here, other than to say that the change that was made, or actually there was no change made by the state of New Hampshire in terms of the nature of the charter, but the content of the charter, it went from being a private college to a public higher educational institute. And that was disputed by the trustees of Dartmouth College in 1819. They took their case to the Supreme Court of the state of New Hampshire, and the state of New Hampshire's court upheld the decision of the New Hampshire legislature to change the charter and to make it, instead of a private corporation run by the trustees, it was now going to be a public college with oversight by the state of New Hampshire. And it was intended to be kind of the seed kernel for a statewide higher educational system. The trustees objected. They ended up taking it all the way up to the U.S. Supreme Court, where the U.S. Supreme Court overturned the decision of the New Hampshire Supreme Court, and went much further than simply saying, no, they got it wrong, that the legislature in New Hampshire shouldn't have changed the nature of the charter to change it from a private to a public college. The Supreme Court under John Marshall as the Chief Justice, and also Joseph Story, one of the other judges on the court, they made some interesting decisions, dicta as they call it. They dictated from the bench and created new law. And in fact, what they did is they changed the nature of a corporate charter as it had been viewed from the beginning of English legal tradition, at any rate, which is where the United States, the new government, borrowed much of the common law from England. And instead of the charter being a grant of privileges from the sovereign, prior to the revolution, that would have been the king, to a group of incorporators. In Dartmouth's case, that's the trustees. The court changed the nature of the charter from being a grant of privilege from the sovereign to a select group of citizens, and declared that the charter was henceforth going to be a contract between the state that issues the charter, in this case New Hampshire, and the incorporators of the corporation, in this case Dartmouth, that's the trustees. Now, when the Supreme Court made that decision and they changed the charter from a grant of privilege from the sovereign to a contract between the sovereign, in this case the sovereign people of New Hampshire, and the trustees of Dartmouth College, by making it a contract, they changed a lot of things. They made it so that under contract law, as we kind of generally understand, neither party to a bilateral contract, neither party to it can unilaterally on their own change the contract, change anything about it, the agreement. Any changes have to be agreed by all parties involved, which means that once a corporation is chartered, and by the way, the Supreme Court's decision didn't just apply to Dartmouth, it applied to all corporations going forward in the United States. that every issuance of a charter by a state, whichever state, to a group of incorporators would now be a contract between the state, representing the sovereign people of the state, and the receivers of the charter, the incorporators. That had profound effects on the power of private corporations going forward. The profound effects were such that the people, once they created a corporation, unless in the charter they put specific limitations on the corporation, they could not, after the charter had been issued, put any further limitations. They could not change the charter in any way without the agreement of the corporation, the folks in charge, the officers of the corporation. And that, of course, created, in a sense, mini sovereignties. The corporations became mini sovereignties with full power of internal governance of the corporation without exterior interference. There actually were some limitations put in charters afterwards. In some cases, they would say, for instance, the charter would have to be, there would have to be a request to renew it after 10, 15, 20 years. There might be a statement saying this charter is only active during, for instance, the erection of a bridge across a river. That was the only purpose for the corporation, was for investors to invest in putting this bridge in place. Once it was in place, that would be the end of it. Some charters would actually extend that beyond it and say that the incorporators could retain the charter of the corporation for X number of years and collect tolls from those crossing the bridge to recoup their investment from the construction of the bridge, as an example. But there were other things that were changed as well in the 1819 Dartmouth case. And Joseph Story, one of the justices on the court, a staunch Federalist, just as the Chief Justice was, they agreed that there should be a distinction between private corporations, in other words, for-profit business corporations, and public corporations, for instance, municipalities, municipal corporations. And the different, why, H, you have your hand up, was that just from practice, or did you want to stop and ask a question?
I have a question.
Okay.
I really appreciate your summary of the Dartmouth case, 1819. But I would like you just to add another sentence or two so I can follow what you're talking about. When the charter law was changed so that charters moved into contract law, and then you talked about a sovereign being created, and I missed that link. Where did the sovereign emerge in that change in the contract law?
Sure, I guess I assumed, but I shouldn't. And so prior to the American Revolution, of course, the sovereign was the monarch of England. Following the American Revolution, the idea was that the people would now be the sovereigns. It was going to be a government of and by the people, and that the people of the state that issue a charter to create a corporation, they are the sovereigns of that state. The legislature represents them, but the sovereignty resides in the people. And so the contract is technically, the contract being the charter now, the contract is technically between the receivers of the charter, that's the incorporators, and in the Dartmouth case, that was the trustees, and the sovereign people of the state of New Hampshire. So the creation of a sovereignty was essentially, the intent was to the creation of a republic, the United States, with the people being the source of all governing authority, as it says in most state constitutions. So they are the sovereigns. Does that answer your question? Okay, great. All right. So the other piece of this is that the creation of two distinct kinds of corporations, private and public. And when I say private corporation, I don't want to confuse things. I don't mean publicly traded. Okay, there are privately owned and publicly traded private corporations. Business for-profit corporations. What was created here was a distinction between public corporations like municipalities and private corporations like for-profit businesses. And what the big distinction is that they made, and Joseph Story really pushed this, was that for private corporations, for-profit, making money corporations, business corporations, their charter of incorporation is a contract between the incorporators and the state, the people of the state. When it comes to municipal corporations, cities, towns, any incorporated municipality, those entities were seen as municipal corporations, which is a type of public corporation, and their charter is not a contract between the residents of the municipality or the government of the municipality and the state. In fact, there is no charter, or there is no contract. It is the claim by the court was that the creation of municipal corporations was for the convenience of the state only, and that is for the administration of state law at the local level. And they left it pretty much at that. And I wanted to bring us up to speed. We covered this in last month, covering the emancipation of property from democracy. And we need this background to move further into tonight's chapter, the Municipal Colonies of America. Now, I'm going to dive into that, and as I do with each of them, I start with a quote, and this one tonight is from Thomas Jefferson. It was from a letter that he wrote to Joseph Cabell in 1816. So 1816 would have been the same year that the trustees brought their lawsuit against New Hampshire because New Hampshire had changed the charter of Dartmouth College to make it into a public college. So this was also prior to the Supreme Court of the United States changing the nature of corporate charters. And this is really about Jefferson's view of how the federal system would work, and that there would be a democratic and republican form of government at several levels. Quote from Thomas Jefferson: "Let the national government be entrusted with the defense of the nation and its foreign and federal relations. The state governments with the civil rights, laws, police, and administration of what concerns the state generally. The counties with the local concerns of the counties, and each ward direct their interest within itself. It is by dividing and subdividing these republics from the great national one down through all its subordinations until it ends in the administration of every man's farm by himself, by placing under everyone what his own eye may superintend, that all will be done for the best." And so Jefferson's view was that each level of government had its purposes, and that those levels of government should not step outside or beyond that authority and leave as much decision making to the individual, to the community, to the ward, to the municipality, and then working up to the state and federal government. That is not the form of government that we have today, although we kind of have a general idea that it is. I'm here to argue that it's not the kind of government we have today. The first section of this chapter is titled Dillon's Rule and John Marshall's Dead Hand. According to Duhame's Law Dictionary, Dillon's Rule, and some of you have heard this term before, Dillon's Rule is, quote, a rule of judicial interpretation. So it's not a law. It's a rule of judicial interpretation that a municipality may exercise only those powers expressly conferred by statute, necessarily or fairly implied by the expressed power in the statute, or essential and not merely convenient. What kind of statute? A state law, in other words. So a municipality may exercise only those powers expressly conferred by state law. That's what Dillon's Rule says. Where did Dillon's Rule come from? Well, Dillon's Rule isn't in the U.S. Constitution. It's a legal opinion developed by an Iowa Supreme Court judge in 1868. And as we've been talking about, in 1819, well before the infamous 2010 Citizens United versus Federal Election Commission ruling by the Supreme Court, and even before the notorious Santa Clara versus Southern Pacific Railroad Company ruling in 1886 declared corporations to be persons under the 14th Amendment, the court began the gradual separation of common people from governing power in the newly proclaimed republic. There was a respite from constitutional meddling in local governments by the court while the expanding American empire claimed more and more of North American commons for itself. It created new territories and states. As it grew, as the nation grew, new communities were intentionally established as municipal corporations. Towns long established prior to the states and the nation jealously guarded their autonomous status and rejected incorporation. But as empire rolled out across the continent on the iron bars of the railroad corporations, judges stepped in and defended the conquest and turn communities into colonies. They stepped in to defend the conquest of the continent, but as we'll see, it was also a conquest of the existing communities and the transference of them into colonies of the nation and the states. There were early expectations in America following the Revolution that community life would be guided locally, democratically, by community decision-making. The traditional New England town meeting perhaps came closest to the ideal. There, every eligible elector had a say in the regular business of the community. But it was not only in Massachusetts, Rhode Island, New Hampshire, and Connecticut that the ideal of direct citizen participation shaped local government. The Township Act of 1798 in New Jersey incorporated 104 communities under a direct democracy town meeting style of government. White males 20 years of age and older who were residents of the town for 6 months, paid taxes, owned land, or paid rent of at least $5 per year were eligible to vote. Direct limited democracy in the townships was retained until 1899, when major revisions to the Township Act abolished the town meeting and a township committee assumed municipal legislative powers. It's also interesting that in 1899, New Jersey is the state, their legislature created a law that recognized a right of corporations, I'm talking about business corporations, private corporations, to own other business corporations. That was illegal until 1899 throughout the country. And in New Jersey, the same year that they revoked the self-governing powers of the townships, they created a new right for private corporate property to own other corporate property. Public opposition to establishing towns as municipal corporations instead of as independent, really freestanding towns was particularly keen in Boston, where town meetings embodied the ideal of communities making their own governing decisions with broad participation. Quote, thus, one pamphleteer lauded the existing town meeting structure as the greatest and most precious privilege any town or society can be possessed of, while directly predicting that, quote, the rich will exert the right of dominion, unquote, in a government of aldermen and councilors. In other words, arguing for the town meeting where all residents could participate. With the advent of the municipal corporation, quote, the great men will no more have the dissatisfaction of seeing their poorer neighbors stand up for equal privileges with them in the highest acts of town government, end quote. Instead, under corporate rule, these so-called great men will gain control, and rich and poor men then will no more be jumbled together in town offices. That's the end of that quote, and it comes from John Tieford, his book, The Municipal Revolution in America, Origins of Modern Urban Government. Opposition by Federalists to direct citizen legislation was strong. James Madison, a critic of town meetings and also a formidable Federalist, wrote in the Federalist number 55, quote, in all very numerous assemblies of whatever characters composed, passion never fails to wrest the scepter from reason. Had every Athenian citizen been a Socrates, every Athenian assembly would still have been a mob, end quote. Thus, the so-called founding fathers of aristocratic temperament, the Federalists, refused to accept that the American Revolution had finally established community self-determination. As we've seen, it was with the Dartmouth versus Woodward rulings that the court took the first step in freeing private business corporations from governance by the people. It's also worth reminding you that the very first grievance against the empire listed in the Declaration of Independence was that the crown, the empire, regularly vetoed or disallowed laws passed by local communities. When you read that language, it doesn't say local communities, but the fact is there were no states prior to the revolution. There was no federal government. It was more than 90 local governments that sent delegates to the Continental Congress, instructing them to separate from the British Empire. And their first grievance was that their local laws were being overturned and preempted. So despite the Dartmouth ruling, the right of the people to use municipal corporations to engage in local democratic self-government was not challenged with ferocity until the end of the Civil War, even though Dartmouth had been decided in 1819. The Dartmouth decision was eventually to prove fatal to the exercise of self-governing rights in American communities. But according to Hendrik Hartog, chair in the History of American Law and Liberty program at Princeton, quote, the law of municipal corporations had not been invented, end quote. So prior to, or should say right after Dartmouth, there really was no developed law of municipal corporations. The new form of public corporation defined by Joseph Story on the Supreme Court. The courts rarely ruled on the nature and scope of local government authority in the early days of the Republic. Explaining further, Hartog wrote, quote, one reason why there was no law of municipal corporations was because chartered cities were already part of an undifferentiated law of corporations. Indeed, in the 1820s, treatise writers still considered the borough the paradigm of corporation existence, echoing the traditional common law perception of a corporation as property investing the people of a place with its local government. For for Stuart Kidd, whose treatise on the law of corporations remained the leading work on both sides of the Atlantic until the 1830s, boroughs were simply one type of civil corporation. Nothing distinguished public from private entities. Those terms played no part in his analysis. And so we see it was judge-made law, the distinction that was made between private and public corporations, and the distinction between contractual charters of incorporation and non-contractual charters of incorporation. American courts and legislatures declined to make a distinction between private and public corporations, despite the Dartmouth ruling, until the incorporated municipalities became divested of their predominantly private characteristics. Once the uses of municipal corporations expanded beyond the protections of property interests, they no longer served the agenda of latter-day Federalists. The Federalists were, of course, committed to the protection of vested rights in property, and they included, as we've discussed in prior months, sections of the U.S. Constitution that institutionalize rights in property as essentially, apparently, much more important than rights in people, because rights in people weren't mentioned until the first 10 amendments were added 2 years after ratification of the U.S. Constitution at the insistence of the Anti-Federalists. So the transition marked a change in the deference shown to municipal autonomy by state governments. The transition from municipalities that were originally set up to protect private interests, and the transition from that to where those local governments were being used for community issues of community interests, to protect the community from various scams or from the railroads, quite frankly. The railroads were laying tracks right down the middle of Main Street and running their coal-fired locomotives and actually setting towns on fire with the cinders coming out of their smokestacks. I mean, it was a kind of thing where people were clamoring for protection against the corporations in that case. So the state withdrew chartered governing rights from municipalities on the presumption that the municipal corporation and the people it spoke for should not be allowed to make judgments impacting private ownership rights unless the municipality were made directly answerable to the legislature. In this way, the role of the state legislature as representative of property privileges and not of unalienable rights was further clarified. The Dartmouth decision was dusted off and reinvigorated in 1868 by the railroad lawyer turned Iowa Supreme Court Judge John Forrest Dillon. Dillon spelled out what Dartmouth had tentatively accomplished for the property class. In the city of Clinton versus Cedar Rapids and Missouri River Railroad Company case, he revived the court's privilege affirming and rights denying dicta with a ruling that protected a railroad corporation from a community's local lawmaking. Following Judge Joseph Story's lead, Dillon denied the community's authority to use the municipal corporation to enact laws to protect community interests against the business plans of the Missouri River Railroad Company. He summarized his opinion years later in a legal treatise saying, quote, "The great weight of authority denies in toto the existence, in the absence of special constitutional provisions, of any inherent right of local self-government which is beyond legislative control." And so anything that the people using their local government could do could be overruled by the state. That's essentially what Dillon's rule says, and it goes further. The shorthand Dillon used to summarize this opinion goes like this: local government is to the state as a child is to a parent. a dependent entity that has no legal agency of its own. What's now known as Dillon's Rule aggressively implements the anti-democratic potential of the Dartmouth ruling. Dillon went even further than Joseph's story. Not only did he think states' ownership of municipal corporations gave the states authority to alter or abolish any powers delegated to the municipality, he extended the power to the state to deny in toto the right of the people to local self-government. So this is an important piece to keep in mind. And why am I going through all of this? It really is to point out the position of our municipalities, the towns we live in now, in terms of their ability to do anything to protect our homes, to protect our kids, to protect our local natural environments, to protect our local economies. We have really had the teeth pulled out of our ability to govern at the local level. So Dillon asserted that the people's right of local self-government had been vested with the adoption of the federal constitution in municipal property owned by the states. It's an argument that purported to turn the right of local self-government demanded in the Declaration of Independence into a right vested in property, the state's property. By vesting what had been the democratic rights of the people in municipal property owned by the state, Dillon privatized a public right. So here we have another example of the court making the rights vested in property publicly enforceable law, while privatizing the rights of the people, the right of community local self-government. Privatize how? By vesting the right in the property, the municipal corporation owned by the state, and thus transferring the right of self-government from the people of the community up to the state legislature. It's been argued by others, and we'll talk about that in a minute, but that the people never surrendered their right to self-government in the places where they live. They never surrendered that, and so according to the 9th Amendment of the U.S. Constitution, that right should be considered to have been retained. Dillon's rule simply blows that off the board and says, nope, doesn't matter. So as a form of property infused with once public rights, municipal corporations became privileged property. And I talked about this in past discussions on these webinars. Difference between privileged property. Privileged property is property in which particular special rights are vested so that whoever comes into possession of that privileged property, like a private corporation, gains those extra privileges. So corporate property has Bill of Rights protections. The owners of those corporations get a double dose of Bill of Rights protections. They already have them as individuals. Now their property has them. So Dillon's rule was applied to all American communities by the federal Supreme Court in 1891. So in 1868, it was only Iowa municipalities where Dillon's rule applied. In 1891, the federal Supreme Court applied it to all municipalities in the country, just 5 years after it declared private corporations to be persons protected by the Constitution's 14th Amendment. So just 5 years after declaring that corporate property has Bill of Rights protections, the court also said, and by the way, people don't have the right to use their local municipal governments for self-government at the local level. The court's application of Dillon's rule to all American municipalities was reaffirmed and broadened in 1907. And I have the case names if anybody's interested in those. The federal court legalized usurpation of every American's right of community local self-government. In doing so, the court placed wealthy private corporations in a legally superior relationship to the counties and municipalities where people now live, bereft of self-governing authority. Dartmouth inspired Dillon's rule, and by way of the contract clause, stripped every American of the right of local self-governance. Dillon's rule, like the contract clause, is a form of private law enforced as public law. And like other private laws, it is exempt from public alteration, regulation, or revocation. So the distinction between private law, contract law, is between the parties in the agreement, and it's lawful, but only exercisable between those parties to the contract. So that's technically supposed to be private law. But when the contract clause through the Dartmouth case was applied to the charters of incorporation, now a private law somehow was transferred into the public sphere. So if the states own the municipal corporations, then who owns the states? If not the people, then who? Why is it a question of ownership anyway? Why is it about property? Because the contracts clause has been thrown into the mix, for one thing. But the answer is to be found in the system of government that the Federalists erected. In every legal confrontation between unalienable rights of people and the rights vested in property, the courts never fail to remember the will of their dead Federalist masters. Dillon remembered Marshall, and judges today remember Dillon. As a result, all municipal subdivisions of the states have been privatized, their governance centralized in the state, where the controlling interest of an aristocracy of wealth holds sway. Revolutions have been justified for lesser transgressions of the public trust. If the Federalists could betray so fair and just a revolution as was waged with Tom Paine's inspiration, then the majority is supine and has no place to retreat. If we are to take a stand, it must be in the communities where we live. That's been the strategy of CELDF's community rights organizing since 2002. Let me stop there and see if you've got any comments or questions. Thoughts? Complaints? You wish it were different? Okay, well, we'll move on to the next section. Let's see. The next, okay, YH, you have your hand up? And unmute so that we can hear you. Okay.
That's
Sorry, I'm not hearing.
Can you hear me?
Go ahead and speak. It sounds
Hello?
like. Hello, go ahead. I'm sorry, we're not just hearing a little bit here and there. Can you maybe type something into the chat and we can take a question that way if you'd like. All right, I'm going to move on, and YH, if you're able to put something in the chat. I know that you're just not on video and don't have a lot of bandwidth there, maybe not, but please just go ahead and break in if you manage to, and if I hear you, that'll be fine. I can stop and take your question. So the next section of the chapter is titled Resource Colonies, Not Hometowns, the Legal Status of Municipalities. The right to govern every American community is up for grabs by whatever combination of wealth takes control of state legislatures. mean, that's what we conclude from the situation following Dillon's rule. It's true that Congress can be relied upon to forbid municipal and state governments from enacting laws to assert the will of the governed community through the Commerce Clause. So Congress can invoke the Commerce Clause and say neither the states nor municipalities can regulate this particular practice because the federal government has claimed complete regulatory authority. When they do that, that requires lobbying and campaign funding at the national level. But the states are the more regular culprits when it comes to inventing pretexts for stripping citizens of local governing rights. Lawmakers do it by revoking all meaningful authority from the municipal corporations the people would otherwise use for this purpose. There have been hundreds of recent state enactments focused on subordinating the rights of communities to the prerogatives of the propertied class. Just a few examples will do. In 2005, the Pennsylvania State Legislature enacted what they called the ACRE, A-C-R-E initiative as Act 38 at the urging of agribusiness and waste hauling lobbyists, including the Pennsylvania Farm Bureau and PennAg, a consortium of factory farm corporations. This law, Act 38, empowers the citizen-elected state attorney general to sue municipalities to overturn local laws that regulate or ban factory farms and urban sludge dumping. Notably, Act 38 places the highest law enforcement officer of the state at the private disposal of corporate waste and agribusiness interests. In other words, the state's highest law enforcement officer, the Attorney General of Pennsylvania, is not only empowered, but has the discretion to sue any municipality that tries to regulate those industries. CELDF organizers were instrumental in working with those communities in lobbying against an even more draconian version of Bill Act 38. Similar aggressive laws against community self-government continue to be adopted by state legislatures across the nation and around the world, preempting municipalities from regulating industries from fracking to agribusiness to aerial pesticide spraying to water withdrawals, you name it, pipelines. The list of preemptions, the things that local governments are not allowed to make local laws concerning, grows as the lobbyists go to town and go busy on the legislatures in the states. Less than a decade later, after 2005, with widespread local opposition to the process of hydraulic fracturing, that is fracking, for the extraction of methane and other fossil gases, industry nonprofit advocacy groups busily lobbied dozens of state legislatures to enact preemptions that would block local fracking bans, prohibitions on pipelines, bans on export terminals, and other industrial infrastructure. In Texas, soon after the city of Denton banned fracking by popular demand, the legislature passed a ban on such local bans. Texas House Bill 2595 followed directly on the heels of the ban on local frack bans. It prohibits cities from validating initiative petitions for local ordinances that would, quote, restrict the right of any person to use or access private property for economic gain. That means if voters in a city attempted to petition to, for example, ban hydraulic fracking as they did in Denton, it would be tossed out before the first signature was gathered because it violates the rights, and I will say the rights is what they call them, of mineral owners and their corporations, their privileges, not rights. And the rights of the people to govern in their communities have been violated by this law. In other words, you can't even put it on the ballot and have the citizens vote to see if they want such a law. They won't even put it on the ballot if it would interfere with profit making that has anything to do with the extraction of fossil fuels. These and their many companion preemptions are the legacy of the Dartmouth ruling. Everything from local bans on plastic shopping bags to minimum wages to prohibitions on water privatization and assault weapons have been overturned at the request of corporate lawyers and front groups. The denial of community self-governing rights is encoded in a legal theory that can no more be located in the Constitution than can the terms corporation or political party. Neither the term corporation nor political party nor Dillon's rule can be found in the U.S. Constitution. The cynicism of proponents of Dillon's rule and the planned incapacity of every American to engage in self-government at home is boundless. While agreeing that each citizen has a constitutional and natural right of self-government, they argue that the state has the authority to forbid public corporations, that is, municipal state property, from being used for that purpose, for the purpose of self-government locally. It's akin to the state conceding that the law guarantees a right of every citizen to ride a horse and then enacting a law that prohibits any horse from bearing a rider. So, what the state gives, it also takes away with the other hand. That's it for this subsection. Any thoughts or questions at this point? Let me see. Do we have a question here? Oh, no. Okay.
Well, I was just coming.
Go ahead.
I'm sorry, but all of that was just, we have to keep a sense of humor, and that's exactly what happened with the last part. It's also so horrible. But then to think, it's okay to have a horse, but not a ride.
Did you like that? Did you like that line?
I really like that. It struck me as a way to keep a sense of humor in the middle of all this.
Yeah. So it's essentially saying that, we believe in the right of self-government, but no, you can't do that you can't use your municipal government to engage in self-government in the place where you live. I do like to say that, if you have a right to self-government, or if the claim is that you have a right to self-government, please show me on a map somewhere where I can exercise the right. And if you can't show me on that map where I can exercise that right, I'm going to say that by definition, the right doesn't exist. Anything real exists somewhere in space and time. We can identify where it exists. I know there are concepts, and the right of self-government is a concept, sure. But if you're going to say that it actually is a living, breathing practice, please show me where. And the one place where we might imaginably exercise self-government is the place where we live. And it's the one place most assuredly denied, where we're denied that right. And I'm of course claiming that the right to vote for candidates is not the same thing as the right to exercise self-governance. Self-governance isn't just about making a decision between candidates that have been chosen by private political parties. And by the way, the two main political parties, they're not mentioned in the Constitution, and they are private corporations themselves. The Democratic Party, the Republican Party, they are chartered as corporations, and they choose as private corporations who the American people may vote for. And as some of us understand, even if there's a primary election, the party could choose a different candidate than the popular vote went for, should they desire to, because that's their rules. That's how the rules are written. Of course, they won't get any fans that way, but they have the power to do it. So, YHICU asked me to expand. I'm not sure what it is that precisely to expand on, but if you can type something and I'll try to come back to that, okay? Our next section is titled Business Corporations Are For Profit and Municipalities Are For Profit. I know that when you hear me say it, you maybe don't catch the distinction, but business corporations are for-profit corporations. They make money, and municipalities are there to help them make money. In other words, that's kind of the intended pun. So the category of public municipal corporations includes not just general purpose governing municipalities like cities, boroughs, towns, and so forth, but also development corporations, water authorities, and school districts. Certain types, especially development corporations, are regularly chartered at request of private business corporations and commercial interests, so that it's a wealthy minority empowered by public rights and money vested in state property who directly benefit. The creation of new towns, boroughs, and cities became a municipal marathon as the territorial claims of the American continental empire expanded westward. Leonard Curry, scholar of the U.S. antebellum and urban history, wrote that, quote, "The city charters that emanated from the new state governments in the late years of the 18th century reflected a hesitant concern to make city governments patterned on old world models, both more responsive to popular will and more in harmony with the political theories of the revolutionary era. Nevertheless, they also bore the marks of a residual and indeed renewed distrust of popular government." In other words, a real federalist twist to them. Perhaps more candidly, University of Michigan research professor Nancy Burns tells us that the idea of incorporating new communities had no legal merit except as it advanced the speculative and pecuniary designs of land developers. She writes, quote, "The first general incorporation of law passed in Louisiana Territory in 1808. 9 years later, similar legislation passed in Indiana and Ohio. In 1825, Missouri passed a general incorporation law. 9 states soon followed. They were Illinois, Pennsylvania, Arkansas, New York, Iowa, Wisconsin, Tennessee, and California and Michigan. So these states changed their laws, brought them into conformity essentially with the Dartmouth decision." Burns continues, "One example of the effort of these early developers is the founding of Grand Junction, Colorado. In 1881, settlers were officially allowed into Western Colorado. To ensure that the town they wished to build would have citizens, the speculators pressed settlers to incorporate the town of Grand Junction. The 33 voters complied, 33 voters. The speculators set up all the ingredients of the town. They built the post office, started a newspaper, imported residents, and set up the meeting to propose incorporation. The developers paid the first mayor's way to the federal land office in Leedsville to file for incorporation. As Kenneth Jackson and Stanley Schultz argue, in the 19th century America, real estate speculators spent much of their time building cities. The rules for municipal annexation and for incorporating a municipality out of unincorporated land in a county or township vary from state to state, but regularly give to the largest landowners the authority to allow or disallow changes in governing jurisdictions. So largest landowners within a jurisdiction end up having veto power over annexation or secession, for instance, of a part of a township to join a different township or to become a freestanding borough. Local majorities are left out of the decision-making in these cases. In short, it is the interests of property and wealth that can partake of local self-government in a way that is even more effective than early property qualifications at keeping the rabble, that is, community majorities, out of the business of voting, governing, and defining new governments. So coming up to the next section is titled Anti-Dillon. It didn't have to be this way. So John Forrest Dillon in Iowa, he had his opinion. But we had another state Supreme Court justice who had a completely different opinion. To the continued chagrin of the Friends of Democracy, the legal establishment, at the same time it embraced John Forrest Dillon's legal theory, rejected the opinion of Michigan Supreme Court Judge Thomas Cooley, one of the era's leading scholars of constitutional law. Cooley argued that municipalities receive their power directly from the people and thus have a kind of limited autonomy. It is the state whose power to curtail local authority that is limited by general rights. Cooley wrote that, quote, the sovereign people had delegated only part of their sovereignty to the states. They preserved the remainder for themselves in written and unwritten constitutional limitations on governmental actions. One important limitation was the people's right to local self-government. Cooley argued that for the people to create state legislatures and then subordinate themselves to their dictates would be absurd. It would contradict the principles espoused in the Declaration of Independence, which says, quote, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. But through a long chain of decisions, the courts have generally rejected Cooley. Dillon's rule was not a legally necessary conclusion. It was a choice made by judges to side with property against the general rights of people. Officials elected to merely administer state law within local jurisdictions cower in the shadow of Dillon's rule. They regularly inform their local constituents that they wish they could help, but their hands are tied. How many people have heard that said in a local municipal meeting? Oh, we wish we could help you folks, but our hands are tied. The state preempts us from doing anything about that. We can't regulate that industry, right? Hear it all the time. This Dillon's rule is what they're talking about. And the people we elect locally are told when they take their office. In Virginia, they go through a little boot camp for county commissioners where it's drilled into their heads. Dillon's rule is God. Dillon's rule prevails. You can't do anything without the state's permission. And then when their constituents come to them in meetings and say, please don't let them create a gold mine here in the county and tear up all of the ecosystems and dump all of these toxins into our local water, what do the local officials say? Wish we could help, but our hands are tied. We're preempted by the state. There's Dillon's rule. Dillon's rule is over our pay grade. That's what they tell them. So during a weekend democracy school some years back, I presented a municipal structure, kind of a graphic of it, of a local governance to members of the Lakota Nation residing at Pine Ridge Reservation in South Dakota. Deborah Whiteplume, a class participant and a resident of Pine Ridge Reservation and of some national notoriety, I'll say, she gazed at my illustration I drew on the flip chart. And after some quiet contemplation, she said out loud, she just said, the white man's municipalities are just reservations like ours. The difference is we know we live on reservations. The white man doesn't. And that about sums up what I'm trying to tell you about municipalities. They are the equivalent of Indian reservations, where the people living there don't govern themselves because self-government is seen as above their pay grade. And that goes for every American. Every American. John, you have a question or comment?
Yeah, I think that's pretty accurate. The difference to me seems like the existing treaties establish a reservation and a tribe as a sovereign nation that's supposed to have a higher level of involvement in their own rights, whereas the municipalities have none. Can you say something about that?
Well, first off, the local government is not mentioned in the federal constitution. There was no, and under the federal system, and I use the term federal not as we think about it today, but the Federalist Party, which was the wealthier folks in the colonies after the Revolution. When they gathered in Philadelphia to draft the Constitution, they did it in secret. And we covered this in earlier parts of the webinar here. But they met in secret. I was born in Philadelphia. I grew up hearing all the stories about how it was the birth of democracy was, this is the cradle of democracy and so forth. But the federal Constitution was drafted intentionally to respond to what was considered too great a degree of democracy under the Articles of Confederation, the first U.S. Constitution. And not only that, but the federal Constitution was enacted in a way that was technically unconstitutional according to the first Constitution. A change to the Articles of Confederation, the requirements for such a change were not met in adopting the current Constitution. One of the differences was that in the first Constitution, the states were essentially independent sovereign states. So when they said United States of America, United States, the word states was plural. Today, when we say United States of America, it's singular because we're not looking at it as though it's a kind of an alliance of independent nations. It's one nation, but there is somehow the invention of dual sovereignty. There's federal sovereignty and there's state sovereignty, but there was no recognition of local sovereignty. Now, I have to say that during the Revolution, the people who actually fought the British, when they picked up their muskets and left their farm crops to rot so that they could go off and declare independence from the empire, they did so in order to gain something more than a new boss telling them how to run their local affairs. As I said, they insisted that the Declaration of Independence include as its first reason for breaking with the empire that the empire disallowed their local laws. The Federalists, when they drafted the second Constitution, they didn't ask for the input of those folks who left their farms behind and fought the British and won. They didn't ask. A matter of fact, we talked about it in a prior gathering about, and we have notes from those meetings in Philadelphia, in which the Federalists agree among themselves that if they could, they would create a monarchy. But they knew that after the Revolution, they couldn't get away with establishing a monarchy again. So they needed to create something that looked like a republic, but worked as closely to form as the British government does, which they thought was the most perfect form of government that the world had ever seen, which is, of course, really an anti-revolutionary stance. To say exactly what the revolutionaries wanted is exactly what we don't want, and we're going to write a new form of government to put that kind of government in place. Local government was not recognized as important by the Federalists because they needed to protect property interests. The land that had been taken by the colonizers, including George Washington, who claimed 67,000 acres in southeastern Pennsylvania and southwestern Ohio, that he would have lost had he not been involved in the Revolution. He would have lost those land claims. The British government had signed a treaty with the Haudenosaunee and the Iroquois Confederation, saying that no land claims west of the Appalachians would be recognized by the Crown after the French and Indian War. That certainly upset George Washington and gave him reason to think maybe we could do something different. There's a lot more I could say, but there was a class structure in the colonies, and the folks who wrote the Constitution represented the wealthy class. Those who didn't own land were not invited to participate in framing the government. And they weren't recognized to have rights either afterwards. I'm not sure if I've answered your question, John, exactly.
No, but what you said is really important. Keep going.
All right. We only have maybe 15 minutes left. And I'm just going to, let's see, go through local self-government and the American Revolution, which partly this responds to. What was really on the minds of average American colonists when they revolted against the empire is easy to discover. Their complaints are listed in the Declaration of Independence. Let's take a quick look at the Declaration and compare the vision of self-government it laid out to the government we ended up with. Did it really call for a central government with veto power over every American community's laws? Did it demand that democratic rights either serve commerce and wealth or face the usurping preemption of Congress, the Supreme Court, and every state? The Declaration, signed on July 4th, 1776, wasn't the original work of Thomas Jefferson, although he gets most of the credit. Some of the inspiring language was lifted from the writings and speeches of the levelers and diggers of England. A century before the American Revolution, those radical groups had manned the new model army that Oliver Cromwell and the wealthy men of commerce raised to depose King Charles I. Jefferson borrowed phrases like consent of the governed and ideas like the people are the source of governing authority from the peasants who demanded the British House of Commons be revamped to represent the common people, and that everyone being equal, peasants should take the reins of power in England. When Jefferson listed the colonists' grievances against the Crown, he borrowed from resolutions sent to the Continental Congress by more than 90 towns and counties throughout the colonies. Among the 30 or so complaints he listed, the very first one mentioned in Jefferson's declaration is the preemption of local laws by the central government. Quote, he, that is the king, has refused his assent to laws the most wholesome and necessary for the public good, end quote, from the declaration. The revolutionaries were not talking about being prevented from making state or federal laws. There were no states, and there was no nation. It was the usurpation of the people's right to enact and enforce laws in their own communities that had them up in arms. Today, across the country, this is exactly what's happening in town after town. States and the federal government are preempting local laws intended to protect workers, immigrants, the homeless, and to fend off resource stripping, toxin dumping, and property confiscation. What American revolutionaries listed as their first order of business to correct through revolution is now the chief counter-revolutionary project of the American Legislative Exchange Council, ALEC. Today's Federalists are as opposed to democracy as were their predecessors. The first salvo against the empire's preemption of local laws was not the last. Other complaints filled the second half of the Declaration of Independence. Most of them condemned interference from London in matters of local self-government. In the absence of local lawmaking authority, appointed colonial governors were also forbidden to enact laws that represented colonial interests. The Declaration says, quote, he has forbidden his governors to pass laws of immediate and pressing importance unless suspended in their operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend to them. So they don't go into effect until the king gives them the nod, and he just ignores them and never even looks at them. In many states today, local laws have no effect until they are approved by officers of the state. Kind of a mirror image of what the revolting commoners of the colonies were complaining about during the Revolution. The revolutionaries rejected the paternalistic idea that the empire would wisely provide for colonial needs so long as the colonists abandoned their right to representation in Parliament. On this point, the Declaration says this, quote, "He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature, a right inestimable to them and formidable to tyranny only." And so they were saying they should have representation in Parliament, that is, the colonies should. And the king was saying, we won't even listen to any of your complaints unless you relinquish your claim to representation in Parliament. So we're no better off today, essentially. The Federalist frame of government that replaced British rule institutionalized the exile of American communities from legislative representation. However well state voting districts are drawn, even without blatantly partisan gerrymandering, communities per se have no representation in state legislatures, as we'll see in part 8 of this series. Americans today have a lot in common with the colonists who found their lives and their freedoms curtailed by bureaucratic shell games. The next grievance Jefferson listed against the empire read, quote, "He has called together legislative bodies at places unusual and uncomfortable and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures." Does that sound familiar? What activist hasn't had to skip a day of work and travel to a hearing halfway across the state to testify before legislators, bureaucrats, and regulators? It's a situation that would be rare if the people's representatives remained in the communities they supposedly serve to learn the will of their constituents rather than gather in ostentatious capitals where lobbyists and paid persuaders have their ear every day. Like communities across America today, the revolutionaries were outraged when the empire legalized the violation of people's rights. And when colonists challenged that oppression with local laws to protect their safety, the empire nullified, vetoed, and preempted them, making local officials and local laws irrelevant. Jefferson framed their complaint this way, quote, "He has dissolved representative houses repeatedly for opposing with manly firmness his invasion on the rights of the people." Much as modern regulatory agencies have multiplied into an alphabet soup of administrative bodies, by the time American colonists decided to declare their independence from the ministerial form of government imposed on the colonies, they were seething with anger. And the Declaration says, quote, "He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance," end quote. This ministerial style of government places bureaucrats between the 99% and the propertied 1% who have the real authority to make decisions. Anyone who has ever had their hopes of prevailing at a regulatory hearing dashed because the agency lacked discretionary power will understand how the colonists felt. These days, Americans can find their local attempts at democratic legislation preempted by international trade agreements, too. Treaties that protect foreign business interests against local laws that erect what are called barriers to free trade were no stranger to the revolutionaries. They objected to such imperial policies that ignored their right of self-determination, and Jefferson included it in the Declaration, saying, quote, "He, the king, has combined with others to subject us to the jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. American courts today don't consider the American Declaration of Independence a precedent-setting document. It's not even considered part of our law. That only makes sense when we realize that the Federalist counter-revolution opposed its democratizing doctrines. Robert L. Brunhouse authored a detailed account of how unpropertied commoners took control of the Pennsylvania Colonial Assembly in 1776 and precipitated a vote in the Continental Congress to adopt the Declaration of Independence. So they took over the Pennsylvania legislature, took it away from the propertied, propertied legislators at the time who were Quakers by and large, and they chased them out. They threatened them with tarring and feathering because they would not agree to send instructions to the Continental Congress to declare independence. And so when the commoners took over the legislature in 1776, they sent instructions to the Continental Congress. Without the insurrection against property qualifications for voting and holding office, and that's what they were initially in revolt against, without that revolt, New York and other states would not have agreed to the Declaration, and the colonies would not have seceded from the British Empire. Brunhouse's book documents how, following adoption of an ultra-democratic state constitution in Pennsylvania and the revolution's success by commoners in pursuit of parallel aspirations, the Federalist counter-revolution unraveled those democratic gains with their conspiratorial drafting and rushed to ratify their federal constitution. The government the Federalists gave us mimics the one that justified the Declaration of Independence, reviewing the causes, as it said in the Declaration, the causes which impelled them to the separation from England, puts into perspective our plight today. It can help us to understand why people in a growing number of American communities are challenging their treatment as mere colonies of the empire. We're almost out of time, just a few minutes left, and maybe just enough time to finish this short final section. And it's titled Federalist False Flag Waving, Irony and the Star-Spangled Banner. And maybe we'll find some humor in this to wrap up the evening. And I will wait, and if you'd like to stay around and talk, ask questions, make comments, I'm happy to stay. So let me just finish up this section for those who have to go. The federalism we got is not what American revolutionaries fought for. The missing ingredient under the current system of government is people deciding their own affairs. Reference to local government cannot be found in the U.S. Constitution. Latter-day Federalists justify this oversight, claiming that efficiency demands that local governments comply with state and federal micromanagement. Anti-Federalist Thomas Jefferson and his mostly rural colleagues disagreed, while the urban Federalist minority spread disinformation as they pressed for a new constitution. Anti-Federalists protested vehemently. The lead up to ratification of the Constitution saw threats of tarring and feathering, among other coercive scare tactics for anyone who openly opposed its ratification. Americans today uncritically accept the Federalist betrayal as the intended realization of our nation's revolutionary heritage. We need to shake free of this deception. We can't correct the mistakes of the past without admitting them and without rejecting the legal obligation to repeat them as hallowed precedent in every legal proceeding. The average American believes that the Federalists were the founding fathers. They celebrate them on national holidays with bunting and stars and stripes everywhere. But they celebrate a changeling history. False memory has replaced truth with fact-free flag waving. Even the old yarn about Betsy Ross and the Stars and Stripes covers up the irony of the Federalist true loyalties. The American flag, as it turns out, is a close replica of the banner flown by the British East India Company, the largest corporation in history. That's the giant British corporation whose tea Sam Adams and the Sons of Liberty famously dumped into Boston Harbor. Those hotheads were protesting the treatment of American colonists as second-class British citizens. They thought Americans deserved representation in the British Parliament more than the company's directors, who engineered a corporate tax amnesty for their corporate property, and had the empire tax the colonists, those what we call consumers now, to make up for lost revenue. Like today, it was the owners of chartered corporations who held sway over government, not ordinary people. Now those corporate red and white stripes are flown triumphantly across the continent. But curious minds might wonder who really won the American Revolution. And I'm just going to hold up this page. This is a little black and white rendition of the flag of the British East India Company. This was a corporation chartered, created, in other words, by Queen Elizabeth in the year 1600. The British East India Company, I mentioned, became very powerful. So powerful, in fact, that it had a larger standing army than the British Empire during the height of its power. And that standing army, where was it standing? In India, in the subcontinent of India. The British East India Company also exercised its power in the American colonies, and as we see, the revolt, the protest by the Sons of Liberty, Sam Adams, who was John Adams' cousin, in Massachusetts. They dumped that tea in the Boston Harbor, and that tea was brought into the harbor by the British East India Company. And the dispute was, why should we let you unload this tea, for which, when we purchase it, we will be taxed, when you have been relieved of all of the taxation that you should by right pay to the British government. Instead, they have passed that off on the colonists. We're making up the difference, and that's unjust. Why should a corporation have more rights than the people in the Americas? And we may ask today, why should corporate property have more rights than American citizens in every one of the towns across the country? And I'll leave it there and see if there's any thoughts, any discussion, questions, comments.